Time is gone 16 minutes after 6 o'clock, and it's a very good evening to you. Welcome to yet again another broadcast brought to you by Government Communications and Information System GCIS on behalf of the Department of Justice. And this evening they're not working all by themselves, but together with the National Prosecuting Authority, the Department of Social Development, as well as the South African Police Services, they've came on board to make this one possible for you and giving you information that you might need. My name is Karabolans, and I'm glad to be spending some time with you this. And we're going to be exploring and learning a little bit more about the Child Justice Act. That's Act number 75 of 2008. And lots of questions arise as far as the Act is concerned. And we've heard parents being concerned about some of the projections within the Act. And we're going to be asking questions and learning a little bit more about that. These are questions like issues around the age of the child. What should we then say? Who is a child? Which age are we looking at? And so forth. We're going to be exploring as well the aim and the role of the Child Justice Act and so forth. And many of these questions will definitely be attended to this evening. So don't move an inch. Parents, guardians, teachers, law practitioners, etc. be part of this one here this evening. And unlike many of the programs that we had, it's going to be more like a discussion type of thing, because we're going to be having more than one guest, or we're going to be having them over the phone, and they're going to be sharing some information that they might have for you. And should you require any information on have any questions or maybe even suggestions, you're more than welcome to call us on 0800 142 446. So that's the magic number for this evening should you require assistance and questions answered. That number, you can utilize it. It's a toll-free number if you're calling from a landline. I'll repeat it again. The number is 0800 142 446. And joining us by way of telephone is going to be Joy van der Heide. And they're coming from the Department of Justice. And they're going to be telling us a little bit more about the Child Justice Act number 75 of 2008. We are getting hold of Joy. But he's not going to be the only person that we're speaking to this evening. How about we speak to Advocate Dion Rater? And Dion is coming from the National Prosecuting Authority. He's going to be giving us information as far as the NPA is concerned and how they come to play and the role they're playing within the Child Justice. We're going to be chatting to Dr. Stan De Smith, and he's coming from the Department of Social Development. The questions that we have with regards to the community development and our children as far as their development and growth is concerned. And we're going to be chatting to Lieutenant Colonel Tazwell. He's coming from the South African Police Services. All of these guys are going to be on the line and information coming to you, and we're very grateful for the time that they have taken to be with us. Joy van der Heide on the line. Good evening to you.
Good evening.
Joy, thank you so much for having taken some time to be with us, and we really appreciate it. We're looking forward to the show here.
Same here. I'm very keen on sharing information with your listeners.
Big ups to the following radio station. They've taken this they've taken this feed to give you information to make sure that you are clued up, to make sure that you and I are learning as far as the Child Justice Act is concerned. And it's big up to Eden FM, and that's 87.8 to 93.3. Thank you so much, guys, for taking part. And Voice of the Cape, you guys came on board as well. Thank you so much. Helderberg 93.6 FM, you came on board as well. Radio KC 107.7, you guys have made it possible for your listeners to get information from us as well. Namakwaland 93.4, that's the land. Thank you so much. Yeah, radio station that's doing very well. Then thank you so much, guys, for taking part as well. Radio Atlantis, Valley FM, Bonnet Radio 8.2 FM. Thank you so much. All of you guys have made it possible for your listeners and for your respective to get information and to learn a little bit more about the Child Justice Act. That's Act number 75 of 2008. Enough said. Let's get straight into the program. First things first. Let's chat a bit more about the Department of Justice and Constitutional Development. Your responsibilities within South Africa. Do you want to tell us a little bit more about that?
No problem. The department is responsible for ensuring access to court services, and that's in terms of the Constitution. because everyone has a right to access court services. So our responsibility is basically focusing on certain court services which the department renders at no cost, like maintenance, domestic violence, claims court, and equality court services. The other part of our responsibility is the provision of interpreters and intermediaries in court matters. And in addition to all of that, our department is also responsible for ensuring the implementation of certain critical legislation, which includes the Child Justice Act.
Mm-hmm. Joy, your specific role within the department?
My specific role within the department is a senior legal administrative officer. So I'm responsible for ensuring and overseeing the implementation of legislation in the courts.
100%. Now, one would like to know that, the Child Justice Act number 75 of 2008, for those people who are not familiar with it, the implementation and the inception of it, how did it come about?
Well, it was a long consultative process which led up to the Act actually coming into existence. You must remember South Africa is a signatory to various international protocols, and in terms of our obligations internationally, we have to enact legislation to see those obligations through. Now, one of the things that we signed internationally with the UN is what's in the rights of the child in a criminal justice system. Because internationally in America and other countries, it's accepted that you cannot have a child being tried in a criminal matter that's designed for adults.
Mm-hmm. And you're talking about consultation. You're saying that there were various consultations that were done. Can you tell us some of the stakeholders that were involved?
Sure. The child law that was involved, the UWC Community Law Center that was involved, and various other non-governmental organizations and universities and other interest groups that practice in children's rights that were involved in the consultation process, including normal public members of the public.
Mm-hmm. Talking about the stakeholders involved in the inception of the Child Justice Act number 75 of 2008, the stakeholders that are going to be part of this broadcast this evening is the National Prosecuting Authority, and later on we're going to be chatting to Advocate Dion Reiter as well as Dr. Stan De Smith, and he's coming from the Department of Social Development. But on the line as well, joining us by way of telephone, coming from the SAPS, the South African Police Services, is Lieutenant Colonel Tazwell. It's a very good evening to you, Lieutenant Colonel.
Hi, good evening, sir.
Thank you so much for having taken some time to be with us this evening. Can you talk about the role that your sphere is actually taking part as far as the Child Justice Act is concerned?
Okay, thank you so much. I think just in a nutshell, with regards to the Act itself, we from the police services also have our National Instruction 2 of 2010 that guides our members in terms of how we need to deal with children. And the purpose of the National Instructions is to ensure that our members treat children in conflict with the law in a child justice system designed to break the cycle of crime, but also to contribute to safer communities and to encourage them to become law-abiding citizens and productive adults in our society. Mm-hmm. And I think the main key with regards to that is that children are different from adults and do not have the same knowledge and experience and insight normally expected from an adult. So therefore, in terms of dealing with children in conflict with the law, we need to treat them differently as we would treat adults. Mm-hmm. And the crux of the matter, and lastly, in terms of an introduction, is that we, as the South African Police Services, must always have the best interest of the child to ensure that we don't discriminate or don't act inappropriately when we deal with children in conflict with the law.
Mm-hmm. That's the voice of LC Tazwell there, coming from the South African Police Services. Now, LC Coswell, now tell me the role, your specific role within the SAPS.
Okay, in terms of our role, we specifically look in terms of how we deal with children, and you find the category that we normally would work in is the category of children between the ages of 10 and 18 years old. And in terms of those categories, there is certain measures that we need to put in place, and in terms of the Act, there is certain requirements in terms of how we deal with children. So in order for us to fulfill our role, we need to acknowledge that we are dealing with children and that we have to abide with the laws in terms of the Act and also the regulations that is stipulated in the Act in terms of how we deal with these children in conflict with the law.
Mm-hmm. Time has gone 26 minutes after 6 o'clock. 0800 142 446. We're chatting about the Child Justice Act. That's Act number 75 of 2008. And we are chatting now to Joy van der Heide, and he's a senior legal administrative officer in the Department of Justice. And we're also chatting on the line to LC Tazwell, coming from SAPS, South African Police Services. Thank you so much for your time. You as a listener, should you have any questions that you would like to pose to these people, you're more than welcome to send them through over telephone 0800 142 446. That number is a toll-free number if you're calling from a landline. I'll repeat it again, 0800 142 446. Coming back to you, Joy. Now, why is it necessary really to create a separate justice system for children?
That's actually a very complicated question to answer. You need to understand that when a child makes a decision to do something, their reasoning isn't the same as an adult. So you can't treat a child on the same level as an adult in that regard when they make decisions. So it stands to reason that if you can't treat a child as an adult because their reasoning patterns aren't the same, then obviously sentences imposed on the children can't be the same as well. Because our criminal justice system before the implementation of this act was only for adults. So you'd get a child that is arrested for example, shoplifting, and not looking at the circumstances of that child as to why the child had to steal food. So you sentence a child in terms of the normal Criminal Procedure Act, which would have been theft and therefore correctional services facility, so it's detention in a prison. Whereas in terms of Child Justice Act, what it's saying is you need to actually look at what led the child to make certain decisions and take that into consideration as well as the circumstances of a child in applying the criminal process to the child. So it wouldn't be fair to sentence a child who was hungry, who stole a loaf of bread, for example, to jail when you should realize that child is a child in need of care and protection and should actually be placed in better circumstances because they cannot fend for themselves. So that's all part of the reasoning as to why it's necessary for a separate criminal justice system for children.
But now, doesn't it make them get away with, if I may say, murder in inverted commas? I mean, if they commit crime, that's the same crime that an adult has committed. And they getting away with murder?
I don't agree on that because you must remember that children cannot, by law, work and obviously earn an income. It's against the law. Whereas adults can work to earn an income in this specific scenario. So the diversion that is utilized for children in certain instances, and not in all cases is diversion used. You must remember, sentencing to a correctional facility, a prison or a jail, is only used as a last resort. It's not first option. So what we do in terms of diversion, when we redirect the child away from a formal court process and criminal proceeding, in that process, we actually encourage the child to, number one, accept accountability for his actions, realize that he or she actually acted criminally and wrongly. It also allows for reconciliation between the victim and the child, and the victim's views are taken into consideration when the child is diverted away from the criminal system, alternatively sentenced.
Elsie, as well, I'm going to be coming to you now, asking you a very important question as far as the procedures that are undertaken when a child is being arrested. So brace yourself for that. But before we jump into that, here's Rachel calling all the way from Atlantis. It's a very good evening to you, Rachel. Thank you so much for having taken time to chat to us.
Thank you, Karabo. How are you doing?
I'm doing very well, thank you.
Yes, basically, we have one call from one of our callers in Afrikaans, but I think what I'll do is I'll basically just ask the question in English.
Except for your donkey.
That there's one question that is a bit confusing, and she explained that a boy is 7 years old and he committed a crime, and the other one involved was 10 years old, and she basically doesn't understand what the Act says in terms of what age a child can be prosecuted, because the Act is a bit confusing about the age of the child. It says something about 18 and 21 and then 10 years and older. So she just wanted to find out from the speakers, anyone, at what age basically can a child be prosecuted according to the Act of 2008. Thank you very much, Karabo. We'll stay tuned.
Thank you so much, Rachel. Thank you so much, Radio Atlantis, for your taking part in this broadcast. And I know that looking at all my database, I can see that you guys have really taken part in most of our broadcasts. And so I think it's very vital. You see it very important for your community to receive information from these broadcasts. And for that, we thank you so much on behalf of GCIS. Thank you so much. Big ups to you guys for a job well done. Age groups covered by the Act. And according to the Criminal Justice Act, a child is someone who is under the age of 18. But now the Child Justice Act, do you want to explain a little bit more there, Joy, in terms of the age covered by the Act?
That's no problem. A child is defined as a child under the age of 18 years old. But in terms of the criminal process, it's internationally accepted, and in our country it's been accepted as well, that a child that's under the age of 10 years cannot be prosecuted by law because they don't have the necessary capacity to reason and to make decisions for themselves. Children between the ages of 10 years old to 14 years old, it's regarded that it's a presumption, and it's a rebuttable presumption, that they presume to lack criminal capacity. What that means is the state must prove that for children between the ages of 10 to 14 years old, they do have the capacity to reason and made a decision, and therefore have to obviously accept the consequences of that decision. Mm-hmm. Children from the age of 14 and over, they are regarded as having criminal capacity. So then the burden is on the defense attorney in this instance to prove that the child lacked criminal capacity.
All right, 0800 142 446. That's the number to dial should you want to be in touch with us this evening. That number is a toll-free number if you're calling from a landline. If you're going to be calling from a cell phone, don't worry about it. Our producers will definitely take your number down and call you back. In that way, we're going to reduce costs for you. So take part in this broadcast, ask questions, and perhaps you might have any suggestions that you would like to share with the panel. You're more than welcome to do that. 0800 142 446. Joy van der Heide is on the line to be chatting to us, and she's the Senior Legal Administrative Officer at the Department of Justice, as well as the SAPS. So thank you so much for the time. It is 26 before 7 o'clock. Now we move on, and one of the most important questions that I would like to ask you, Elsie, is the question around the processes of arresting a child. What are those processes? That's 100%. Now, in other words, when you arrest a child, are the same process of arrest taking place? In other words, are they also being read their rights? Is it important to read them their rights since they're minors? How does it work?
Okay. In terms of the criminal procedure, the same process is followed, but there's a distinction when we deal with children. Like Joy explained earlier on, in terms of if you determine that the child is below the age of 10, then we know in terms of the Act that the child don't have any criminal capacity, cannot be arrested, cannot be charged, and cannot be convicted of any offense. Mm-hmm. When we deal with a child over the age of 10 years old, firstly what we do is that we need to determine what is the offense, and then we've got different schedules of offenses, which is a Schedule 1, a Schedule 2, and a Schedule 3. For example, a Schedule 1 offense would be theft less than 2,500 rand, committed assault. Schedule 2 offense would be, example, assault to do grievous with body harm, housebreaking, and Schedule 3 offense, which is our most serious crime, is murder, rape, robbery with aggravated circumstances. So in determining the type of offence the child is involved in, then we from the police side, we have determined if the child is over 10. In terms of, say for instance, it's a Schedule 1 of a less serious offence. Then what we do is that we issue a written notice to the child and the parent or the guardian of the child in terms of the offence that has been committed. Also, with regard to that, we need, if the child acted on its own, then we need to trace the parent or the guardian for the appropriate adult in that case of that particular child. And in terms of that necessary documentation is then completed, the child arrested, but in terms of the act, the child is then released in the care of the parent until the preliminary date that is set in terms of the
23 minutes before note. Welcome, Dion, and you coming from the National Prosecuting Authority. Thank you so much for taking time to chat to us, Advocate.
Good evening, and good evening to our listeners.
Advocate, what are some of the rights that a child offender has as far as they being arrested on the spot? What is it that one can look out for in terms of their rights not being violated?
Okay, when it comes to children, in terms of the Child Justice Act, a child under the age of 10 cannot be arrested. But I don't want our listeners to get the opinion that when a child is under the age of 10, nothing will happen. The only thing is that we will not deal with that child in the criminal justice sector. We will deal with that child in a court setting, but it will be part of the children's court inquiries in terms of Section 150 of the Children's Act. So the first focal point is children under the age of 10 will not be arrested. The police will issue a document called the SAPS 583A. That document is then given to the parent of the 10-year-old or the child under the age of 10, and that will go to a social worker that will compile a report that will go to the children's court inquiry where the commissioner, that is a magistrate sitting at a court, in a children's court inquiry will decide what should happen to that specific child under the age of 10. If the child is over the age of 10 and it is a Schedule 1 offence, the police will issue a document called the SAPS 583B document, and what it means is a child should not be arrested for a Schedule 1 offence. So I've heard that you discussed the Schedule 1 offences. I'm not going to repeat it. So all the Schedule 1 offences, children should not be arrested for those offences, and the police will issue a SAPS 583B. If it is a child over the age of 10 and it is a serious offence like rape, murder, or armed robbery, which is Schedule 3, the police obviously can effect an arrest, and the child will be brought before a court of law within 48 hours where the officer will do an assessment and deal with that child in accordance with the law. But what the children's rights are, the child should know that if he is under the age of 10, he cannot be arrested. If he is over the age of 10 and it's a Schedule 1 offence, the police must give him a 583B form. They cannot just arrest him for a Schedule 1 offence. And a child can have his guardian or his mother or father with him when he's going to appear in the court of law.
0800 142 446. That's the number to dial should you want to be in touch with us. Perhaps you've got some questions that you would like to ask us. We are more than happy to be answering those questions. I would like you to use the telephone number, which is a toll-free number, if you're going to be calling from a landline. I'll repeat it again, 0800 142 446. And if you're going to be calling from a cell phone, don't worry about it. Make the initial call of contacting us, but as soon as you can, just mention to the producers that you're calling from a cell phone. What they will do is take your number down and call you back. And in that regard, we're going to be cutting costs for you so that we can help you. So 0800 142 446. Now, Elsie Tazwell, when it comes to the length of a child in custody, how long should that be, and not more or not less?
I think in terms of the detention of a child, it shouldn't be in the extreme case where there is arrest being effected, then it shouldn't be more than 48 hours in terms of if it's a Schedule 3 offence. Also in terms of dealing with a child, is that the interest of the child must always be acknowledged, so that in terms of the arrest that has been affected, in terms of the detention, as well as the placement of the child, all those circumstances must be taken into account when we do arrest a child for a serious offense.
Mm-hmm. Are these children, when they're arrested, are they being kept in the same cells as adults?
Okay, a child must be detained separate from adults and also boys separate from girls. In terms of our police stations, we have a specific cell which is marked for the detention of children. So, but like you said, and all the other previous speakers, is that would be the last resort in terms of the Child Justice Act.
Mm-hmm. Some of the big terms that I've heard, I mean, we talked about diversions, we talked about assessments and all of that, and we're going to be finding out a little bit more about that coming up later. And also we're going to be hearing from the spokesperson of the SAPS, that's Zwelimnisi, projecting what the minister has spoken about. That's all coming up later, so make sure that you don't move an inch. But for now, Bonsid from Kailicha, Bonele FM, thank you so much, guys, for taking this feed. Bonsid, good evening to you. Bonisile? Okay, I think we've got a bit of a problem there with Bonisile. Bonisile, we've lost you there on the line. We're going to try to get our producers to call you back. I would like to hear what you have in your mind and what you would like to share with us this evening. So do like Bonisile is doing this evening. Don't sit there with questions that you are not answered with regards to. So you can give us a call on 0800 142 446. I'll say that number slowly. It's 0800 142 446. Don't use it for your lotto number. It's not going to work. So do likewise. Bonisile, good evening to you.
Good evening, sir.
Bonisile, I'm going to ask you to please shut down your radio before we commence. I would like to help you to the best of my ability. I can only do that if your radio is off.
Oh, you're off now, yeah.
100%. What's on your mind, sir?
Yes, on my mind. I don't know if maybe I'm out of your program.
Let's see.
But
Let's see if we can help you. You've called in and we appreciate that.
say again?
Let's see if we can help you. Whatever you have on your mind, share it with us.
Okay, what I have in my mind is when I was 10 years old, in 1990, yes, I was arrested. And I can't remember how many days I spent in jail that time. Not in jail, but actually it's police station. I think it's 2 days or 3 days. Then but fingerprints were taken at that time. But I was not aware that I've got a criminal behind my name until this year. I've been working all the years for the other companies. Then after that, every time there's that section that is asking you to go to criminal record, I always say no, and then nothing else. But only this year, when I'm looking for work now for the other company, then I find out about the criminal record. So now I don't know where to go or what process must I do. At the moment, I'm not working because of that.
All right, if my math serves me right, you're 32 years old today.
Today I'm 32 years, yeah.
100%. So at the time of you committing the crime, you were 10 years old.
So maybe I was 10 years old at that time, yes.
Stay on the line a little bit here, but let's check out with there's two people that I would like to ask to help us with this question here, and I would like to start with Advocate Dion Reiter. Advocate, maybe jump into that as far as criminal records are concerned. When a child commits a crime at 10 years old, and a couple of years later they only find out that they've got a criminal record, is that in place? Is that something that should happen?
Well, there is a new provision in our child justice legislation called expunging, and that is Section 87 of the Child Justice Act. So in the case of Bonisile, what will happen now, in a case where a child commits a Schedule 1 offense, and has been sentenced, whatever the sentence option might have been that the court exercised, then after a period of 5 years, that record will be expunged. Now, what expunge means, it will be as if it's erased. It's completely gone. It doesn't exist anymore. So it will not affect a person that commits a Schedule 1 offense in future, and you will not have to go to an employer and say that I would like to have a job, but I've got a criminal record. It will be as if he never had that criminal record. But if it's a Schedule 2 offense, that Schedule 2 offense, in terms of Section 87 of the Child Justice Act, will expunge or it will elapse after a period of 15 years. The unfortunate part is Schedule 20 offences, that's the murder and rape cases, they can never expunge. So in those cases, they will stay on that young offender's criminal record. But if it is housebreaking, theft, or any of those type of Schedule 1 offences, it will be erased after 5 to 10 years, and the young offender will go on with his life and will be able to participate in economic activity, get a job, and be part of society without having to always refer back to what offense he committed while he was a child.
I tell you what, I want us to be as effective as we can and efficient as we can as far as answering this question is concerned. And I might ask some difficult questions here, Bonisile. And I'm going to ask you, Bonisile, you're more than welcome to say, no, I'm not at liberty to answer that question, but this would be to the best of your ability. I'm just trying to find out, Bonisile, what have you done? The reason why I'm asking you this question is to really gauge it as far as Schedule 1 to 3. Under which schedule does it fall under? So we can help you properly. Do you mind answering that question, Bonisile? What did you do?
No, I don't mind. I think I'm at Schedule 1. I went hunting, man, on the farm. That time when I was staying in the Eastern Cape, man. And we went hunting. According to that thing, when it's saying contravening the nature reserve or whatever, I can't remember exactly now. But it was for hunting, illegally entering, like they trespass, some sort of like that.
So it's more like trespassing, that type of thing. Okay, Bonisile, it sounds to me like it's trespass. Stay on the line just a little bit more. Advocate Dion, it sounds like a trespass type of thing. What do you see here? Where does it fall? Schedule 1, 2, or 3?
Excellent. Trespassing, if you look at the schedules in terms of the child justice legislation, trespassing is, the offences in Schedule 1 is listed. And number 11 is trespassing. So, Bonisile's trespassing should have expunged or will expunge within a period of 5 years. But since he committed the offence when he was still a youngster, you can just apply to the Department of Justice to get his record expunged. It should have been expunged. It should not even have been on his record up until.
Okay, having said that, Elsie Tazwell, why has it taken so long for his record to be removed? It shouldn't have been there.
I can't answer in terms of the it is still on the record, but as the Secretary has explained, is that it is now in terms of Sebunile, if I'm correct with his name, that can approach the authorities to ensure that we remove that from his record.
Department of Social Development, Dr. Stanley Smith, to Dr. Stanley for a bit too long. Moving forward, what is it that Bonisile can do? Okay, let's go back to Joy van der Heide. Joy, what is it moving forward? What is it that Bonisile can do?
What I would suggest Bonisile does is go to his nearest magistrate's court in the area that he lives, ask for the expungement of criminal record forms, complete it, attach a copy of his ID as well as a certified copy of the record reflected on the criminal nervous center, which is with the police, and then apply through the department to have it expunged. It will have the same effect as in terms of the Child Justice Act, where his record will be cleared completely as if the crime did not happen.
Thank you so much for that. Bonisile, are you happy?
Yes, I'm very happy. But now I want to know maybe the process, how long it will take.
There we go.
Does it mean now I must maybe stay out of work for the next 6 months or a year?
All right. The time period anticipated here with regards to the clearing of that criminal record, Joy?
Well, the clearing of the criminal record is a decision that's not taken by us in the region. It's a decision taken and implemented by our national office in Pretoria. But what Bonisile can do, if you don't mind, is you can give him my contact number and I'll put him in touch with the relevant person in Pretoria so he can get the answers to those questions.
Thank you so much for that. Bonisile, our producers are going to give you the number for Joy van der Heide. She's the Senior Legal Administration Officer at the Department of Justice, and she'll definitely help you on that regard. Thank you so much for your call. I really appreciate it. 0800 142 446. We are chatting to Advocate Dion Reuter. Dion, am I mentioning your surname correctly? Every time I mention that, I get the jibbies in me.
No, it's completely correct. Don't worry, it's correct.
100%. I'm happy for that. And you're coming from the National Prosecuting Authority's offices. Thank you so much. And LC Taswell, it's pretty long for me to say Lieutenant Colonel. I might just bite my tongue there, hey?
No, it's fine.
So I'm resorting to LC Taswell. It sounds nice for radio as well. So you see, 0800 142 446, and that's the number to dial. Should you want to be in touch with us this evening, we'll be happy to be answering your calls. We're talking about the Child Justice Act. That's Act number 75 of 2008, and it was implemented 2 years later, if I'm not mistaken. Hey, Joy?
It was implemented a couple of years ago, but the department started working before the implementation of the legislation together to put systems in place. So when the act came, it wasn't a matter of us running over our feet because the systems were already there to process children.
Mm-hmm. Coming up later, we're going to be chatting, we're going to be hearing, from the spokesperson of the SAPS. That's somebody that's working together with LC Taswell there, and his name is Zweli Mnisi. He's going to be giving us some of the projections as far as what the minister has said with regards to the high rate of children in the Western Cape, the high rate of them being arrested. And the minister's not really happy about that. So we're going to be hearing what Zweli Mnisi is saying coming up later. So stay tuned. Don't miss out on that. 8 minutes before 7. This is a live broadcast. It's brought to you by Government Communications and Information System on behalf of the Department of Justice. And together this evening, they've partnered with the National Prosecuting Authority. They've partnered with the Department of Social Development. And later on, we might be joined by Dr. Stan De Smith. He might be coming on the line coming up later. So brace yourself for him. And if you've got any questions with regards to things like traumas that are being experienced by children being arrested, he'll be able to handle that type of thing. And maybe you know of a child, or you were a child yourself a couple of years ago and you were arrested and you're battling with some of the things and you would like to know how you should be treated or how you should be helped. He's going to be there to help you, as well as LC Taswell coming from the South African Police Services. Thank you so much for them for having taken some time to be with us here. 0800 142 446. That's the telephone number to dial. I got a blank patch there for a bit. Let's move on. And one thing that I would like to know there, Advocate Dion, is the court procedures. Do minors, we're talking obviously children less than 10 years old, children between the ages of 10 to 14 and 14 plus, do they go through the same court procedures?
First of all, children under the age of 10 obviously don't go to the court procedures. They go to the commissioner, and that is being done at the Children's Court Inquiry, which is not a formal court setting the way we know courts. The children from the age of 10 to 14 will appear obviously in what we call a child justice court. But they'll only appear in a child justice court in a case where, let me explain it from the beginning. You've heard about assessment. After assessment, there is a process that we call the preliminary inquiry. Now, a preliminary inquiry is where a magistrate, which we call a preliminary inquiry magistrate, will sit and decide on what should happen to that specific young offender. Is he going to go home with his mommy? Is he going to go to a youth care center? Is he going to go to a youth care prison, or whatever the case might be, depending on the type of schedule of offense that he committed. So he will first then appear in and I'm referring to me because in most cases we find that our young offenders, 80% of them will be male perpetrators that commit offenses, and the other 20% will in some cases be children, female children committing offenses. But the child will first go to a preliminary inquiry where the magistrate will decide whether that person, that young offender, can go home with his mommy. Is he going to be released on bail or whatever the case might be? Can the case be diverted to the diversion programs? Or in a case where he doesn't plead guilty and he doesn't admit that he did anything wrong, it will, in terms of Section 63, go to the Child Justice Court, where the young offender will be given an opportunity to then test his case, whether he's guilty or not. And then from there onwards, if he's not guilty, then obviously the expunging process can kick in. But those are the different options that will happen to a child right through the criminal process.
Thank you so much for that note. We'd like to welcome Stan. And you coming from the Department of Social Development. It's a very good evening to you, sir.
Good evening.
Dr. Stan, what role do you play within the Department of Social Development?
Then I'm contracted by the department to assist with the probation officers with the implementation of the Child Justice Act.
The implementation of the Child Justice Act. Thank you so much.
To assist probation officers or to see where gaps are,
Mm-hmm. Let's talk about something that affects minor offenders, if I can call them that, as far as their rehabilitation is concerned. What are some of the programs that the Department of Social Development has in order to assist them post the, let's say, the hearing as far as the act of crime after it's been committed?
Okay, they can go on to diversion programs, level 1 diversion programs. That's for minor offences, Schedule 1 offences, where they can go on, for the easy things like school orders, attendance school orders and things like that, or a level 2 diversion where it can include go to a residential facility for a certain time. And to address their need, if they got a sexual problem, to a sexual program, or they got a drug problem, to a drug program, where social workers or probation officers will work with them intensively.
Mm-hmm. 3 minutes before 7 o'clock. It's a very good evening to you all the way from Kaeli. We've got Tuso. Good evening to you, Tuso.
Good evening.
How are you doing, Tuso? What is your question?
Yes. May I ask my questions in Xhosa? I'll be sure.
Ma. You can do that.
Okay. Ngizothatha le-article related to the gangsterism eyenzekayo apha eKhayelitsha. And unfortunately, umama lululate ukuthi iminyaka ethile ngokubona according to this act ukuthi yenze kanjani. But I want to break it down to the children at the age of 12, 14 that about terrorism.
Yeah.
And then if they get arrested, sometimes they even get dispersed when they come and come back to terrorism the next day. And sometimes you find when they are arrested, they are makulwa to care yabazali of their parents. And sometimes you find that the parents only say in court yes because she or he is afraid of this violent child. And sometimes uyayazi ukuthi mhlawumbe loluphi uxanduva according to the act abanalo, because most of the time these kids they go back to the same act after ukuthi bakhulumile to the care of abazali babo ukuthi ngabajonga ngazo.
Ndiyabulela Tuso. There we go. Time is gone 6 o'clock. Jump in there, Elsie Tazwell, with regards to minors being involved in gangsterism. Now, obviously, we've mentioned before that most often we I think it was you, Elsie, that you've mentioned that there's forms that got given to parents to fill in, and these kids are being taken into the hands of their parents. They've been given to their parents to take care of, but sometimes it's not effective. You find that these kids go back again, they commit the same crime. What is your response to that? Are you dealing it with? Are there any other things that you're doing to deal with this pandemic?
Okay, thank you. In terms of the process, and I think in terms of what each department's roles and responsibilities is that it's very clear that in terms of when we do encounter young offenders, as we now mentioned in terms of that particular incident, where they resort back to their old habits, is that in terms of the process, when we do divert the young offenders to diversion programs, there must also be checks and balances. If somebody is taking note of in terms of do they comply with that diversion program that is set out by the magistrate, and do the young offender comply in terms of what was set out in the order in terms of that diversion program. And that is where our probation officers or the person designated to monitor that young offender plays a crucial role in terms of where the child has been placed or in terms of what supervision he has been put under. Because ultimately, if we have our checks and balances in place, there must be a report back to the magistrate that this young offender did comply or does comply with the requirements or the instructions that has been put by the magistrate in terms of that particular order. Mm-hmm. Should there be an instance where this young offender does not comply, then we must come back to the initial phases in terms of where we had, in terms of made a case for diversion and explain to the magistrate that the child has been placed in a diversion program. From his side and his parents' side, there's no commitment in terms of the diversion program. Then we must go the route in terms of which is our last resort, that we effectively deal with the offender in terms of as a serious, or not a serious offender, but in terms of non-compliance from that particular young offender, and find out an alternative sentencing that would rectify that particular behavior of the young offender.
Figures that are going to be shocking to you. Not you only, but the minister was not happy with them as well. And this is what we're going to be listening to right now. This is the voice of the spokesperson of the SAPS, Zweli Mnisi.
It cannot be morally correct for us as a society to have over 50,000 kids being charged for criminality. That is why today the Minister of Police, Nathi Mthethwa, emphasized and made a call to the nation to say the parents be involved in terms of raising their children, because as a South African Police Service will continuously ensure that we intensify the war on crime, but also we are targeting those perpetrators who would normally utilize or influence children to commit crime. And to this end, we want to make a commitment to the public that we shall fight crime smartly and toughly, but we are saying it is a collective effort, and that is why we all have to work together to ensure that our children are safe from crime.
We're talking about helping smartly, Vabe. That's what Zweli has mentioned there. Now, Dr. Stan, how can we achieve this? Is there a way that we've put in place in terms of making sure that the community buys into the whole thing of making sure that the 50,000 mark that we have gone up to goes down in the future?
It's going to be a difficult take on that. It's going to be very difficult because I think the community out there want the eye for an eye and tooth for a tooth, you know. They want people to be punished. And this act, the Child Justice Act, wants to give the child a second chance in life. But we have to work intensively, or people have to work intensively with the child to get them out of crime and not for them to reoffend. But if they do reoffend, then they should be punished. But the prison sentence must be the last resort and for the shortest possible time. But we have to get them out of crime with crime prevention programs, with programs to help them, assist them, and ascertain what is the problem, why they get involved in crime, and to get them as soon as possible out of crime. But drugs is a big problem in our communities. We know most of these, about 80% of these children commit crimes due to drug abuse. So I think that is a main concern to the community.
Mm-hmm. In Zulu we say el kocho al semanzi. In Sepedi se palam twali duwala sale metsi. In other words, you spare the child, you spoil the rod, and that's what a lot of parents that's what they probably are feeling right now, and they're saying, "Hey, this should start at home." But you see, a lot of parents are feeling like the power has been taken off their hands in terms of disciplining their kids. The whole thing about corporal punishment, LC Tazwell, what is your take on it? Obviously, the Constitution is against that, and the acts are against that as well. But what is your take on it to those parents who feel, "Hey, listen, the best way that we can help you is to give them a hiding"?
Yeah, I think that is the outcry of most of our communities and the communities that we deal with on a day-to-day basis in terms of our social crime prevention projects. But in terms of the law, corporal punishment is no more. So we need to find effective ways in terms of how we can dish out punishment to youngsters, but also to have it inclusive that the end that punishment is not only the last resort, it's also in terms of what systems we do put in place as a collective, not only from the police side, but also to acknowledge that the child has certain needs, and in terms of how do we address the root cause of that particular crime, so in order that we can ensure that that child doesn't commit the crime again. Also, what is very prominent in our communities is also that parental guidance from parents or the absent parent, for that matter as well, that also contribute in terms of how the child conducts himself when he's on his own. So there's a number of factors that influence the behavior of the child ultimately at the end of the day. But in terms of our roles and responsibilities as different role players and stakeholders in the criminal justice system, we have to find programs that can really turn that child around, that we can break that cycle of violence, and also to equip that youngster with the knowledge and skills to better himself, irrespective of the circumstances that he or she finds themselves in.
You're listening to a live broadcast brought to you by Government Communications and Information System, GCIS, on behalf of the Department of Justice and together with the National Prosecuting Authority, the Department of Social Development, the South African Police Services. They came on board to help you understand a little bit more about the Child Justice Act number 75 of 2008. And on the line, we're joined by Advocate Dion Rater, and he's coming from the National Prosecuting Authority. Dr. Stan Smith, he's coming from the Department of Social Development, and not forgetting LC, Lieutenant Colonel Tazwell, and he's coming from the South African Police Services. 7 after 7, 0800 142 446 lines are flashing at the moment, and we're gonna be seeing what else we can touch on just before we wrap up the show. But I think something that's very important for me and for the listeners, I think, to understand is the whole diversions thing. Maybe you would like to explain how exactly the diversions work from start to end and the procedures in between that, Joy.
I think that Dr. Stan Smith would actually be best placed to discuss diversion. But what I will do is basically just cover what happens in the terms of the court process. In terms of the court process, what we do is the child will be brought before a magistrate, because there's different stages at which we can divert a child. Either the prosecutor can decide the child must be diverted because of the circumstances which led the child to commit the crime, or the magistrate, or at any stage before sentencing. And what gets taken into account is issues like the circumstances of the child, whether the child acknowledges that they actually did wrong and committed a crime, and accepts responsibility for that. And it also allows for the victim to come in and express their views, as well as all affected members of the community to come forward and raise their view as to what they feel in respect to the crime that was committed. Other issues that get looked at is what was the circumstance of the child. Was the child influenced to commit the crime, or was the child doing it for other reasons? Mm-hmm. Also then hear what the parent or appropriate adult has to say about it. And once they've considered all of those issues, they then decide to divert a child to a program. Mm-hmm. But in diverting a child, you must understand that it doesn't mean that the child is not getting some form of punishment for the actions. The punishment, I think, long gone are those days where we have corporal punishment and we beat the children, to get them on the right path. We have to be more creative in respect of punishment when it comes, not think of it in the archaic way of the child must get a hiding. So this is what diversion practice work instills in them a sense of self-worth, of dignity, of the fact that there is some form of forgiveness, for them to realize that along with their rights comes responsibilities, and the fact that they cannot just do as they please, but they actually need to be productive members of the community and of society. Mm-hmm. But it's correct what my other colleagues have indicated. We do have a huge problem with regards to drugs. And the biggest problem that we have also is that children learn by example. And that needs to be taken into account. So if you have a child who is displaying tendencies towards violence, you have to look at where is the child learning that from. And obviously rectify that situation and that behavior. it's the only way for our children to learn also what is right and wrong in terms of society. Mm-hmm. But I think that Dr. Stan Smith can touch on more with regards to the actual process after the court has now taken all these things into consideration, how the diversion is implemented.
Mm-hmm. Dr. Stan, very briefly, we've got about 3 minutes to go.
Okay, the magistrate can only refer a child to an accredited program, a diversion program. And what we mean by accredited, it must be accredited by, the program must be accredited by the Department of Social Development. And at the present moment, there are a couple of programs that are accredited, but I don't want to go into details about that. But one of the most important things about diversion is also the supervision. The supervision by a probation officer or assistant probation officer. It's not just the attending of the program, but also the supervision whilst the child is under a diversion program, and also to involve the parents, because parenting skills must also be developed. As the lady rightfully says, the parents can sometimes be the biggest problem to our children. Mm-hmm. So the example they set, so the parents must also get involved, especially with the younger kids, those under 10 and those between 10 and 14. I think for them it's important that the parents should also, especially when it is the first or the last session of the diversion. But most of the time it is family out orders, good behavior orders, peer association orders and things like that, and supervision and guidance. That's the level of diversion, and you can combine it or you can put all those things together. And as I said, the level 2 diversion is for the more serious crimes when children committed Schedule 2 or a Schedule 3 offense, and then they can be placed on a longer term and a more intensive diversion program after the assessment by a probation officer. And those included, I won't say inpatient, but in a facility in a child and youth care center where they can be placed for 3 months for intensive with an intensive program like a sexual offences program, drug problem, program for the drug problem, and all those kinds of things to address the real problem, why the child get involved in crime, and then the child can be released back into community under supervision of an assistant probation officer. And at the end, the child might come back for another term, and this period when the child is under 14, it can be up to a year, or over 14 to 18, it can go up to 2 years that the child can be under the diversion program.
Coming up to 14 after 7 o'clock, and it's time for us to say goodbye. It has been an informative program, I must say. Joy, any parting words from you? Contact details if people want to get access, or want to access more information with regards to this. Contact details, email addresses, websites?
Yes, no problem. If there is any need for more information, they can visit our website. It's www.justice.gov.za. Alternatively, they can phone our office if they're in the Western Cape. It's 021-462-5471. And anywhere else in the country, they can phone the respective regional offices or our national office at 012-315-1111.
Thank you so much, Joy van der Heide, and she's coming from the Department of Justice there. Thank you so much for having taken some time to be with us, Joy. Please don't hang up. Our producers are going to speak to you now pretty soon. Thank you so much, Advocate Dion Reiter. You coming from the National Prosecuting Authority. Thank you so much for having taken some time to be with us. Hold your line. Producers are going to be chatting to you as well. Dr. Stan, thank you so much from the Department of Social Development. All our producers would like to say thank you in person to you as well, so please keep on holding your line. And hey, LC Tazwell, not forgetting you, coming from the South African Police Services, thank you so much for that. Hold your line, they're going to be chatting to you as well. Thank you so much, guys, I appreciate it.